For motion, item 1.
Yes.
May I please, we are directed to submit documents as regard with the appointment of the village council as a Soratri. This is the document.
You bring it now, we should have submitted it by way of an affidavit, and also your, the rules which you're relying on. Okay, these are the ones, yes.
Yes.
Because without having these rules, we cannot really go through your matter, isn't it?
Lordship,
Yes.
as per village council election rules 2007, that section 7, Lordship, page that is 4.
Yes.
The publication of the names of the members of the village councils. The names of the members of
Wait, you're reading from
section 7, Lordship.
7 of?
It's page 4.
Okay, election of village councils, is it?
Yes,
Okay.
page 4. That is Chakma Autonomous District Council election of village council rules 2007.
Yes.
Section 7. These publications of names of the members of the village council. The names of members of the elected and those nominated for various village council shall be published in the constituency as soon as may be after the election is over. So this is, and accordingly, the names the State Election Commission has published elected members of the Azasoratri village council, Lordship, that is in the next, that is Azasoratri
Not audible,
village
audible.
council, Lordship, that is
What's going on?
page 2024. So there are 5 members are elected. So this is notified as per the State Election Commission. Lordship.
Yes.
So it is elected, and they are the 5 members are elected.
Where page?
Page 20, that is page that is page number. Separately, we have given Lordship this booklet. There is
Where?
the next
Okay, yes.
State Election Commission. Second page, that is name of the elected members of the Azasoratri village councils. It is published.
Now, all this, I think you should incorporate this in the way of an additional affidavit so that a copy can also be furnished to the respondents if notice is going to be issued. Isn't it? Especially this is not even an act or a rule, this is a part of your
Yes.
submission. Isn't it?
Yes.
This, the elected,
Yes, as we are directed to produce the document, Lordship, that we are just producing the document.
by way of an affidavit, have everything on record, because especially this elected, okay, rules and act is a different matter. You produce it, but then this should be a part of your document in your
Yeah.
affidavit. You should have produced this initially. So I think it should be in a form of an additional affidavit so that this document is also duly furnished to the respondents. Isn't it? Heard Mr. A.K. Roku, Learned Counsel for the petitioner. It is seen that the Learned Counsel for the petitioner has produced the documents required in terms of this court's order dated, what was the last date? 29/07/2024. This court, on perusal of the documents, find it appropriate that the additional documents should be laid before this court by way of an affidavit, additional affidavit. Okay. Accordingly, this is matter in the next week.
Obliged.
For admission, item 2, 3, 4, and 5.
My lord, respondent number 12, SP Kople, chief engineer, was released from his service. Then we have a new chief engineer. The same may be implemented. Great process.
The most recent impleadment was respondent number 14. 14 is the newly impleaded. Okay, now what happened? Someone else has been, what? Someone else has been transferred?
Yes, respondent number 12 has been transferred.
12 has been transferred. Then you'll have to file an impleadment application.
Let's keep on filing
Yes, yes.
without disposing. Anyway, we'll do it.
We'll have
but
to do
they have already filed the so-called reply.
But he has to be the
Yeah,
present
only the
person, isn't
namesake,
it? Yes. Heard Ms. Dinari Elazu, learned counsel for the petitioner, along with Mrs. Zairem Sangpui, learned counsel for respondent number 12.
12.
The learned counsel for respondent number 12 submits that the present respondent number 12 has been transferred. So, Ms. Dinari Elazu, learned counsel for the petitioner, has prayed for time to file an impleadment application. In view of the above list, after 2 weeks? Yes. What about the other
Lordship,
cases? This is,
you have filed
this is item,
in item number 2.
in item number 2 is when
Yeah,
respondent
yeah.
number 12 has been transferred. So
I know.
impleadment application
Lots-
in 2,
lots of
yes.
it. You have filed IA, impleadment of the Deputy Commissioner of Siaha.
Where's
Recently,
the IA?
yeah, IA, you have filed. My information here.
This has been allowed. Impleadment applications have been disposed of.
No, recently. It's
So
not
this
listed, or
impleadment-
I think
wait,
it's
let
not
me
yet
see.
listed, I think.
Impleadment application is for the impleadment of,
VL
yes,
Croizel,
respondent number 14.
Croizel Kiangte, the present Deputy Commissioner.
Yes, so cancel the previous order. I thought another impleadment has to be filed.
Yeah.
Respondent number 14 in place of respondent number 12, is it?
Yes, instead of, now it should be respondent number 15. A new incumbent came again. This is, yeah. Anyway, I think it's not listed today. You already filed. Anyway, let them list it.
No, you're saying that you have filed an impleadment application which
Yes.
has not been listed today.
Yes.
Is it?
Yeah.
So the impleadment application which you have filed is to replace the transferred respondent number 12, is it?
Yes, yes.
Okay. So, Ms. Zairem Sangpui, so-and-so, submits that the respondent number 12 has been transferred. Then, full stop, then Ms. Dinari, so-and-so, learned counsel for the petitioner, submits that they have recently filed the impleadment application on the transfer of respondent number 12.
I'm sorry, Your Lordship. Here
What?
it's 13. Lalmuan Sangan Namte, Deputy Commissioner.
Okay, instead of 12, make it 13.
Yes.
Okay. However, the matter has not been listed.
Yes.
The implement application has not been listed today. In view of the above, list this matter in the next week. Now, this is for item number 2. What about 3, 4, and 5?
Yes.
Same? Maybe the numbers will have to change. Instead of 13,
Yes,
it will
yes,
be?
yes,
Just check
that is
item
correct.
number 13.
Yeah.
No, item number 3. This is item number 2. Now, in item number 3,
Right, right.
contempt 22.
Yeah, right.
DC is respondent number?
DC is respondent number 13 here.
Same,
Same.
yes. Then, in item number 4,
4. Same.
okay, the same order for all
Same
the,
order.
Item 6.
6.
yes, who is the counsel for respondents? Miss Mary L. Kyankte, isn't it? Miss Denari Elaji, learned counsel for the petitioner is present. However, none appeared for respondents number 1 to 3, comma, 5 and 6.
Your Lordship, in here, respondent number 3 has filed additional so-called reply.
It is seen
And
that
the rest,
Mrs. Mary L. Kyankte is the counsel for the said respondents, and she has submitted her leave of absence. First of- In view of the above, list after 2 weeks.
yeah, Your Lordship, it's a contempt matter. It's you have waiting for so long.
But
And
what to
that-
do?
Yeah,
We can't proceed without the respondents, and this is at the individual capacity, isn't it? So list after 2 weeks. Let's see.
Item 7.
My lord, I am for the respondent number 3.
May I please, Lordship?
Yes, 7.
My lord, I just
Yes.
received instruction, then I may be given 3 weeks time for filing my affidavit.
Now, the learned CGC has prayed for 3 weeks' time to file her counter affidavit. We'll allow that, isn't it?
Lordship, may I please, Lordship? Lordship, now the matter, like Lordship, 1 year and 8 months already completed, Lordship. Still today, the respondent have failed to file their affidavit,
No,
Lordship.
no, my lord, they just directed the
Lordship,
petitioner.
in that case, Lordship, last opportunity may be given, Lordship.
No, because if we look at this
Lordship.
court's order dated 06/03/2024, okay, we were still waiting for notice to be returned,
Yes, yes, my
AD
lord.
card not returned,
We just
etc.
received, my lord.
Okay, so maybe it took time for notice to be served. But after the AD card is returned, they have yet to file their counter
Yes,
affidavit.
my lord.
Yes.
Lordship.
So heard, Mr.
B. Chakma, Lordship.
Okay. Learned counsel for the petitioner along with Ms. Zairam Sangpui, learned CGC for respondents number 2 and 3. We'll stop.
3.
The learned counsel, the learned CGC, okay, has prayed for further time to file the counter affidavit. Since
Lordship, interim order to be continued.
she has yet to receive instructions.
Lordship, interim order to be continued.
Praise aloud. List after 3 weeks. Meanwhile, interim order passed earlier shall continue till the next returnable date.
Lordship, can it be on 12/9, Lordship? 3 weeks, please.
Okay, after
On
3
12
weeks,
September, Lordship.
on 12 September 2020. Yes.
Come here, boss. Come here.
Item 8.
My lord, in this matter, in this contempt matter, the respondent number 10 has been impleted and notice has been issued. And in the last court date, I was directed to track the postal consignment of the notice. So, and the postal consignment shown that the notice has been delivered on 4/6/2024 regarding the respondent number 10.
Yes, heard, Mr. Jonathan El Silo, Learned Counsel for the petitioner. The Learned Counsel submits that in terms of this court's order dated 26/07/2024, he has taken steps to track the postal consignment. And accordingly, he has submitted the document which shows that delivery was confirmed on 04/06/2024. Full stop. The next paragraph. In view of the above, notice is deemed to be complete upon respondent number 10. None appeared for respondent number 10.
And my lord,
What about the other respondents?
yes, my lord, in this matter, the main respondents, since the incumbent has been changed a lot, that's why it has come to respondent number 10, my lord. But in this matter, as the court has earlier reflected, the main respondents are the respondent number 4, 5, 9, and 10. 4, 5, 9, and 10 are the main respondents. Others have been newly incumbent.
So any Bakalat Nama filed on behalf of
Yes,
the
my
other
lord. Yes, my lord. Number 4 and 9 has been represented by R.J.D. Chowdhury, Learned Counsel.
Okay.
And number 5 has been represented by Mr. S.K. Medi, CGC.
Then we'll wait for some time. It is seen that
My lord, only one thing is that they have filed affidavit. 4, 5, and 9 has filed affidavit. The affidavit. 10 has not filed, as we've seen.
it is seen that the other respondents number 4,
4, 5,
5,
and 9 are the main respondents.
and 9 are not represented today. However, they have filed their counter affidavit.
Yes, my lord. And my lord, one more thing is that after filing of the affidavit, again, respondent number 9 has been replaced, newly replaced.
So in pleadment,
That's what, my lord, they have filed the affidavit. So do we need to implead?
they have to still be pleaded. Okay.
Then
The
we will
Learned
file an
Counsel
impleadment.
for the petitioner further submits that the respondent number 9 has been transferred and he may be allowed to file an impleadment application.
For the new incumbent.
Yes, for the present incumbent. In view of the above, list after 2 weeks.
My lord, obliged, my lord.
Item 9.
Your Lordship, I'm appearing on behalf of my senior, Mr. Lalfak Omar. And
Speak louder, I can't hear you. Yes.
I'm appearing on behalf of my senior, Lalfak Omar, and there is a connected case regarding this WPC in writ appeal number 4 of 2024, and orders are awaited, and this writ appeal is listed on 28 next week. So
Okay, yes.
so can this WPC 86 be listed after 2 weeks for admission hearing?
Heard, miss? Your good name?
Lalremrati Rentley.
Lalremrati Rentley, appearing on behalf of her senior, Mr. Lalfakoma, Learned Counsel for the petitioner. It is submitted that the writ appeal number 4/2024 which is an appeal against the judgment and order dated 15/02/2023, passed in WPC number 170/2019, is still pending before the division bench of this court and is listed on
28.
2807, no, 2808, 2024. The learned counsel submits that the outcome of the said writ appeal may be awaited since the said writ appeal covers the instant case. In view of the above, list after 2 weeks.
Obliged.
Item 10.
My lord, in this case, at this stage, my lord, if I may make one submission, my lord. I am very sure my learned friend is going to ask for some time, my lord, for filing the additional affidavit. So, my lord, in this respect, if I may point out, my lord, this additional affidavit, which my learned friend is going to ask for time to file a reply, my lord, we had filed it on 26/6/2024, my lord.
What is the additional affidavit required?
So the additional affidavit is with respect to the, because in this case, my lord, the issue is very small. The issue is with respect to the qualification of the respondent number 5 to the post he is holding in the NIT, my lord. As petitioners, we are challenging it because we were in the panel list number 1. We are saying that firstly, he was overaged. And secondly, we are saying, my lord, his degree is not a qualified degree. So the additional affidavit is with respect to his degree.
Yes.
So we filed that additional affidavit on 26/6/2024. So the case was listed after 2.5 weeks on 15/7/2024. On that day, they had asked for time, 2 weeks time, my lord. So all total, by that time, they had already 2.5 weeks. And today, my lord, it is listed again. They have not yet filed their additional affidavit.
Where is this person residing? This person?
He is in Chaltan, my lord.
It's all on you.
He's
my lord.
Aizawl.
Chatlan.
Everyone
That's
is in
not
Aizawl.
quite-
I may be given only a week's time to file.
Have you contacted him?
Yes.
Then what
He
happened?
will be coming.
What's his excuse for not giving you, providing you the required documents?
That documents, some of the documents he has to collect it and then.
Collect it from where?
I don't know. Then he will come this week and we'll sit down and by 1 week's time we will be filing. My lord. We'll
So
take-
since the
make
time
sure that
we
we will be filing within a week's time.
Since the time we filed that affidavit, my lord, 26/6/2024 till today,
It is some difficulty. We could not file it on time, but I'm seeking 1 week's time for filing this time.
Okay, heard Mr. Joseph Lalsan Himarantli, learned counsel for the petitioner, along with Mr. Shohan Subedi, learned counsel for respondent number
Fine.
5. The learned counsel for respondent number 5 has prayed for further time, for 1 week's time.
Yes.
You can serve further to file the additional
To the
affidavit in
affidavit.
opposition.
counter the additional affidavit filed by the petitioner.
Affidavit,
Okay,
yes,
additional affidavit.
dated 26/6/2024. My lord, at this stage, my lord, before your lordship pass the order, let me just interrupt, my lord. My lord, I have one, if I may humbly make one suggestion, my lord.
Yes.
So, my lord, yesterday, the respondent numbers 1 to 4, they filed their affidavit in opposition yesterday. I received it day before,
Okay.
day before yesterday, my lord. So I will file a small reply by next week, my lord. So
Okay,
let this matter come up as a
further time to file the affidavit, additional affidavit. To bring on record certain documents which was allowed by this court order dated 15. When did this court allow you to file your affidavit?
26/6.
No,
Which is allowed by
the affidavit was filed on 26/6/2024. The order was 27/5/2024.
Which was allowed by this court by its order dated 27/05/2024.
And the affidavit is dated 26/6/2024.
Forget about the date, okay.
Yes.
The learned counsel for the petitioner has also prayed for time to file an affidavit in reply to the counter affidavit filed by respondents number 1 to 4. In view of the above, list this matter in the next week. No, after 1 week.
After 1 week, and my lord, if
What?
if a fixed date may be given, my lord, if it's possible. I mean, my
We
learned
will
friend,
file it, and once
there'll be
comes
some
up, then we
deadline,
can
my lord.
fix a date
otherwise.
for hearing.
Okay, list on, after 1 week on,
4th
give
of
me a
September.
date.
4th of
4th
September.
September 2024.
Obliged.
Deeply obliged, my lord.
Okay, wait, 4th September is a Wednesday, so we'll make it 5th.
Yes, sir.
DB day,
Yes,
is
sir.
5th September 2024. Yes.
And my lord, in the meantime, the affidavit should be filed.
Yes.
Item 11.
May it please your Lordship.
Yes.
Lordship, I am appearing in item number 12. Lordship, item number 12 and 13 are connected to bail applications connected to the same trial, my lord.
Yes.
It's an CB trial going
Regarding
before the
item number
special.
13, Your Lordship, I'll be filing my objection affidavit today, my lord. And regarding 12, I'll still have to pay time for 1 week, my lord, for obtaining instruction.
Now, you are appearing for which case?
Lordship, I am appearing item number 12, my lord. This is the
12,
pre-arrest
okay.
application and I am on interim protection, my lord. In item number 12, my lord, if your lordship peruses the earlier order dated 25/7 and 9th of August, lordship, I am under interim protection and as per direction of this honorable court, I have already appeared before the trial court and submitted my bail bonds, my lord.
So at present, you have been granted bail,
I have been granted interim bail by
Interim bail.
honorable High
interim
Court.
bail. Okay,
They
yes.
now enjoyed it, Lordship. They are now on releasing bail.
And we have joined the trial, my lord. Yesterday, one witness was examined. I have appeared. I have cross-examined the witness, my lord. My learned friend, Mr. Subedi, is conducting the trial, my lord.
Regarding that, my lord, I still have to obtain instruction on
Okay.
item number 12. And regarding 13, I've already got it and I have it ready, my lord. I'll file it. I'll have it
Yes.
filed today, my lord, regarding 13.
Now, the learned counsel for the respondent in item number 12 submits that he has yet to receive his instructions. Okay, so we'll fix another date.
My lord, 2 or 3 weeks, my lord. Let him have sufficient time.
Heard,
And in the meantime, Your Lordship, if I may, Your Lordship, there is one clerical mistake, I think. And
One?
LCR is stated to be received by this report, but it is only case diary, my lord. So, proper LCR may kindly be called for.
it has been charge sheeted
Charge sheeted already. Trial is now
Trial
going.
going.
in item number 13,
Both, my lord.
12 and 13.
They are relating to the same case.
Yes. Heard, Mr. Your good name, please?
Deep, D. Boido, item number
D.
12.
Bordeaux, learned counsel for the petitioner, along with Mr. Cesar Ramtanga, learned special PP for
LCB, Lordship.
NCB. The learned counsel for the petitioner has prayed for time since he has to yet receive his instructions in the matter.
My lord.
In view of the above, list after 2 weeks.
Oblige.
Lordship may fix a date, my lord, because we might physically be
On?
present before.
Okay,
Any
on,
date, learned friends,
give me a
convenience, my
date
lord.
after 2 weeks.
12
12,
September.
12 September 2020,
Yes, my lord.
2024. Okay, now
My
in
lord,
item number
Interim,
13, yes.
Interim.
Is
my
there
lord, 12, the
interim?
interim may continue, my lord.
Meanwhile, the interim bail
21st.
allowed previously is to continue till the next date of listing.
Very deeply obliged, my lord.
Yes. Now, in item number 13, C. Faxwala is appearing.
I'm appearing for the applicant.
Heard Mr. C. Faxwala, learned counsel for the applicant, along with Mr. Cesar Ramchana, learned special PP for the respondents. The learned special PP submits that he has filed his written objection.
I'm about to file today, man.
Okay, he will be filing his written objection within the course of the day. He further submits that the scanned copy of the LCR may be called for. In view of the above, scanned copy of the LCR is to be called for. List the matter on the same date. Okay. Yes.
Obliged. Deeply obliged, my lord.
Yes,
If I'm
what-
not mistaken, in item 12, instead of respondent, it is mentioned as petitioner, counsel who prayed that time. So can it be
Which one?
in item 12?
12?
Yes, instead of respondent, I think it is mentioned as petitioner's counsel. Maybe,
It is Cesar Ramchana,
Yeah.
isn't it? Yes.
like,
Item 14.
Just check. Huh? Yes.
May it please your lordship. This is a case of seizure of 2 kgs of heroin from a vehicle, Bolero pickup, AS10 AC 1929, driven by the applicant. Now, my lord, in this case, there are three accused. Accused number one is Mr. Zakir Hussain, wherein his statement was recorded by the IO, and wherein the allegation against him was that he was the real owner of this seized heroin. But the Lanat Special Court, in its order dated 5/7/2024, was pleased to release him on bail. If I may.
On what grounds was he released? Let's
there-
read the order.
There was a violation of Section 42 while effecting the arrest, and due to that reason, Mr. Zakir Hussain, who was the owner and who was in conscious possession of that seized heroin, which was kept in the vehicle driven by the applicant, was released.
No grounds of belief.
No grounds of belief.
Yes.
It was on a technical point that he was released. Now the statement of this Zakir Hussain was recorded, and the IO, he stated that this Mr. Zakir Hussain confessed before him that he was the owner of the seized heroin. So that was the point that I'll just first raise. My lord, there is a deposition of the witnesses at page 86 to 91. Esailarin Sanga,
86.
86. Since trial has already been started,
Yes.
may I apprise your lordship of the deposition? My lord? May I read, my lord? On 28 August 2023 at around 1 p.m., I received information from my source stating that two non-Mizo persons were suspected to transport some quantity of heroin from Champhai by means of a Bolero pickup bearing registration number AS10SC1929 and requested me to take action as per law. I reduced the information in writing and submitted to the OC Anti-Narcotics Squad. On the evening of the same day, self and my party headed to Seling and waited for the arrival of the reported vehicle. I also arranged civilian witnesses from the locality of Seling. The aforesaid vehicle arrived at around 8 p.m. and I recorded my grounds of belief and conducted search of the said vehicle and suspected that some contraband drugs were concealed inside the floor lining of the said vehicle. On interrogation of the accused Bakul Uddin and Sabir Ali, I came to know that some quantities of heroin were concealed inside the floor lining of the said vehicle. Since we cannot recover the seized article at the PO, we took the vehicle to a nearby workshop and cut open the floor lining of the said vehicle. On opening the floor lining, we recovered 149 soap cases containing heroin, and the same along with the aforesaid vehicle Bolero pickup bearing registration number so and so were seized by me in the presence of civilian witnesses. Weighing of the seized article was done at the PO, and altogether it was 2 kgs. Packing and sealing was also done at the spot in the presence of civilian witnesses. I also arrested the accused Bakul Uddin and Sabir Ali for possessing the seized article in the presence of civilian witnesses. I then submitted my report of seizure and arrest to OC Anti-Narcotics Squad. Exhibits so and so, and cross-examination, my lord. I do not know the owner of the seized Bolero pickup bearing registration number AS10SC1929. That while I received the information report, I was in the Excise Commissionerate office near Tennis Court, Rizal. It is a fact that in the information report, the name of accused Bakul Uddin was not mentioned. It is a fact that as far as my knowledge is concerned, no mobile phones were seized in connection in the instant case. It is a fact that my informer in the present case has not been listed as prosecution witness in the instant case. It is a fact that in the instant case, I have conducted search and seizure of the vehicle and also seized the contrabands from the said vehicle. I also arrested Bakul Uddin and Sabir Ali, hence I have not taken any further action except report of seizure and arrest. It is a fact that I do not know the person named Vung Kantona. It is a fact that I record the actual seizure and destruction of the secret chamber from my mobile phone made in the above mentioned vehicle, but I could not produce the same in the court since my mobile phone is now inoperable. It is a fact that I do not remember the name of the motor workshop which I have mentioned in my examination in chief. I also do not remember the name of the motor workshop owner. It is a fact that the workshop owner has not been cited as prosecution witness in the instant case. It is a fact that the accused Bakul Uddin did not mention that he knew that there was a secret chamber in the above mentioned vehicle. Even though I stated before the investigating officer that Bakul Uddin knew that there was a secret chamber, but it was not mentioned in my statement recorded by the investigating officer. It is a fact that there is no forwarding memorandum to go down by the seizing officer as mandated as per Form 1 under Rule 5, Subclause 1 under NDNPS, Seizure, Storage, Sampling and Disposal Rules 2022. I cannot say as to whether Bakul Uddin knew that there was a secret chamber in the aforementioned, since I did not record their statement after their arrest. It is a fact that I do not know whether the accused Bakul Uddin and Sabir Ali could read and write Mizo language. It is a fact that I am not deposing falsely before the court today. My Lord, on appreciation of this deposition made by the seizing officer, my Lord, the seizing officer in his cross-examination, para number 11, Your Lordship may see at page 88, which I have just read. It is a fact that the accused Bakul Uddin did not mention that he knew there was a secret chamber in the above mentioned vehicle. Even though I stated before the investigating officer that Bakul Uddin knew that there was a secret chamber, it was not mentioned in my statement recorded by the investigating officer. But on a careful perusal of this deposition, it came to light that Bakul Uddin did not know that there was a secret chamber in the vehicle, even though the seizing officer was trying to impute upon him that he knew. And the IO had also, and he also stated before the IO, but nothing has been mentioned in his statement before the investigating officer. If I may kindly take Your Lordship to page 49. Page 49 is in Mizo vernacular and page 49A is in English. If I may read the English version. My name is Alarin Sanga. I'm working as Sub-Inspector of Excise and Narcotics, Anti-Narcotics Squad, and currently posted Azor. On 28/8/2023 at 1 p.m. in the afternoon, I received an information from my informer saying that one Bolero pickup registration number AS10 SC 1929 transporting huge quantity of heroin from Champai. I reduced the information into writing. Thereafter, with some of my colleagues, we went to Champai Road to proceed the information received. We reached selling at night time. I requested two reliable persons, Pu Lalchuna Makolni and Pusi Lalmunsanga, residing from selling to witness our proceedings, and they accepted the same. We encountered the Bolero pickup at selling, and there were two non-Mizo occupants. I also requested Pulom Sauzol of selling branch YMS secretary concealing the heroin. As we could not open the lock, we took the vehicle at a nearby shop. We opened up the lock under the vehicle. We took out some suspected to be heroin kept in soap cases. We were suspicious that they still concealed some more in it. By using the driller, we drilled the floor of the vehicle. Thereafter, we found out multiple number of suspected heroin kept in soap cases, which was concealed under the floor of the vehicle. All the heroin were kept in 149 soap cases, 106 were kept in blue, and 43 were kept in green. Thereafter, the suspected heroin were weighed. Altogether, the weighmen were 2 cases. Packing and sealing were done at the spot. On this same night at 10:45 p.m., I seized the heroin. I also arrested the transporter two non-Mizo Bokuludin and Sabir Ali. I also seized the motor vehicle, Bolero, pickup registration number AS so-and-so, along with its keys as it was used for transporting the heroin. Intimation of arrest were given to the family. Thereafter, I also submitted the report of seizure and arrest to the officer in charge Anti-Narcotics Squad ASOL in writing. Now, in this statement of the seizing officer recorded by the investigating officer, nothing has been mentioned that Bokul Uddin and Sabir Ali knew about the secret chamber in which the heroin was allegedly kept or transported. Now, if I may take your lordship to the statement of the accused persons, Bokul and Sabir Ali, page 40A, 40A. Four zero B is the English translation.
Yes.
My name is Bokul Uddin. I am a driver by profession, a resident of Karimganj. On 25/8/2023 at around 4 p.m., I, along with my friend Sabir Ali, came to Azor from Karimganj, carrying Supari in a Bolero pickup AS so-and-so, which belongs to Arbes Ahmed, and I was paid rupees 3,000 for carrying charge. The vehicle belonged to Arbes Ahmed. Marot, I'll just skip at this point. The vehicle which belonged to Arbes Ahmed was hired by Mr. Zakir Hussain. I'll come to that later. And I was paid rupees 3,000 for carrying charge. On 26/8/2023 at around 5:30 in the morning, we unloaded the Supari at Azol main bazaar. While we were unloading, Zakir Hussain called me up through phone. He told me to go to Zemabok to load 15 bags of cement and said that he was going to pay the money through GPay. He told us to load Supari from Champai. The vehicle owner will earn rupees 40,000 for carrying charge, and we, the driver and handleman, will earn rupees 20,000 each. As per his instruction, we carried 15 bags of cement and proceeded towards Champai. At around 11 to 12 p.m. midnight, we reached Champai. We made a phone call to Zakir Hussain. He gave us someone's number and we talked to conference call. Thereafter, we proceeded towards New Champai. He also told us to take the route of Nalan. On 27/8/23 at around 2 a.m. in the wee hours, we reached Nalan. 1 kilometer before reaching Nalan, two male persons, one non-Mizo and one Mizo, were waiting for us with their bike. From there, we both were given a ride on a motorbike by a Mizo person, whereas our vehicle was driven by the non-Mizo guy. Mizo guy told us to take bath, have food, and to take rest, and we were taken to the village to one lady's house as guests. Thereafter, me and Sabir Ali had food, washed ourselves, and took rest at the residence of the lady. In the morning, the seamen were still not unloaded, and we asked them as to why the seamen were not unloaded. However, the lady owner of the house told us that the owner of the seamen is not available at the moment and told us to carry back the seamen. We called up Zakir Hussain through phone, and he told us to carry back and throw the seamen on the roadside on our way back, but we refused to throw and carried on to sell it to our hometown and move out in the morning on 27/8/2023 at 6 a.m. Zakir told us not to take the same route but to return from different direction, and we asked him as to why we should not return from the same route. Zakir then replied by saying that there is a box secret compartment below the vehicle and told us that there are some goods inside it. We then checked the floor of the vehicle and found 3 boxes. Thereafter, we moved out to return back from different route. Even though we were not familiar with the route, we still proceeded by talking through phone, but after reaching Tuol Cheng, we lost signal, we could not talk, and we lost our direction. We do not know where to proceed. Then we returned back to Nalan, and due to wrecking of motor brake pipe, we spent the night in the vehicle. The next morning on 28/8/2023 at around 7 a.m., we proceeded towards Champai, and after reaching New Champai, we repaired the brake pipe. After repairing was done, we again proceeded towards Azor. At night, around 7:30 p.m., we were intercepted by Excise and Narcotics duty at the outskirts of Seling. Civilian witnesses were called and they checked our vehicle in the presence and from the box which is below the vehicle, and they found 149 of heroin kept inside the soap cases. On the spot, Excise and Narcotics duty weighed the heroin and it weighed 2 cases. I, along with Sabir Ali and our vehicle, were arrested by the excise and narcotics officer. The deposition of Bakul Uddin and Sabir Ali are the same. Now, if we carefully appreciate this statement, my lord, the applicant and Sabir Ali, they knew about the secret compartment only when, after reaching Nalan, not from their initial journey.
So where's this Sabir Ali, the other person?
Sabir Ali, he is in custody. He has not approached this court. Now, I'll take your lordship to the charge sheet, page 22.
Yes.
The history of the case in brief is that on 28 August 2023 at 1 p.m., SI Larin Sanga received a reliable information from his source that two non-Mizos transported some quantity of heroin from Champai by means of vehicle Bolero pickup bearing registration number AS10SC 1929 and requested him to take necessary action. SI Larin Sanga recorded the report in writing and informed the officer in charge ANS. He, along with some others, went to Seling village to pursue the report. On reaching Seling village, SI Larin Sanga requested three inhabitants of Seling village, namely Lalchuano Makolni, Sial Munsanga and Lomsang Zuala, to witness the proceedings, and they accepted the same. In the night of 28/8/2023, the duty team intercepted the said village as Seling village. The duty officer recorded his grounds of belief as per section 42 of NDNPS Act 85 to enable him to search and check the said vehicle. The duty team broke the secret chamber under the floor of the said vehicle in which some quantity of heroin was concealed. The duty team recovered 2 kgs of suspected heroin kept in 149 soap cases from the said vehicle. SI Alarin Sanga seized the said suspected heroin and Bolero pickup bearing registration number so-and-so with its ignition key, which was used for transporting the said heroin. He also arrested the alleged possessor and owners of the seized article, namely Bakul Uddin, so-and-so, and Sabir Ali at Seling village. In presence of reliable independent witnesses, packing and sealing of the seized articles was done on the spot. On his preliminary interrogation with the accused persons, SI Alarin Sanga came to know that the real owner of the seized article was Zakir Hussain, and he was proceeding towards Karimganj from Azol. SI Alarin Sanga informed the matter to the officer in charge anti-narcotics squad Azol. The officer in charge requested the officer in charge Excise and Narcotics Station Viringte to pursue the matter. On 28/8/2023 at 11:15 p.m. at Viringte, SI Larin Thanga arrested Zakir Hussain in connection with the aforesaid seized articles and case number cited above in presence of reliable independent witnesses. The accused Zakir Hussain was engaged into the case number cited above on 29/8/2023. The seized articles was deposited to the go-down in charge anti-narcotics squad of Excise and Narcotics Azol by the seizing officer. The seizing officer also submitted report of seizure and arrest to the officer in charge anti-narcotics squad of Excise and Narcotics Azol. The officer in charge registered the case under Excise and Narcotics case number so-and-so dated 29/8/2023 under section 21C of NDNPS Act 1985 against accused Bakul Uddin and Sabir Ali. The case was endorsed to me for investigation. On 29/8/2023, I took out the seized article from the officer in charge anti-narcotics squad of Excise and Narcotics Azol. The accused persons and the seized articles, along with a prayer to remand the accused person, were sent to the Court of Chief Judicial Magistrate. During the course of my investigation, I examined the accused persons in normal atmosphere and I recorded their statement, which I reduced in writing. I also recorded statements of seizure witnesses, arrest witnesses, and the seizing officers. On 29/8/2023, I completed inventory of the seized articles before H.T. Lalmoizola, Judicial Magistrate First Class, Azol Judicial District. The original sample so-and-so was sent to FSL Azol on 30/8/2023 for chemical analysis. On 12/10/2023, I received test result of samples from Forensic Science Laboratory so-and-so and were found to be heroin, the purity of is about 82% at the time of examination. On 31/8/2023 at 9 p.m., I arrested the accused Zoram Chuana, son of Sal Nuna of Nalandarnam, Veng et Saltlang in connection with the instant case, in presence of reliable independent witnesses, but I could not establish any prima facie case against accused Zoram Chuana. I pray the Honorable Court to discharge him from the liability of the charge and to set him at liberty on 29/9/2023. I also seized documents of the said vehicle, on 29/9/2023. Now, my Lord, Zoram Chuana is not an accused in this case. My investigation revealed that the accused Zakir Hussain hired the seized vehicle, Bolero, pickup bearing registration number AS10 AC 1929 at the rate of 80,000 to procure and transport the seized heroin. The accused Bokul Udin and Sabir left Karimganj for Azol in the afternoon of 25/8/2023. On 26/8/2023, the accused Zakir Hussain informed the accused Bokul Udin and Sabir Ali to procure some quantity of heroin at Nalan village. He informed them that there was a secret chamber under the floor of the seized vehicle for concealing heroin. On 26/8/2023, accused Zakir Hussain bought 15 bags of cement at Zemabok Azol at the price of 6,500 for concealment of heroin. The accused Zakir Hussain bought the seized heroin at the rate of 10 lakhs and he paid the said money through GPay to the seller on 27/8/2023. The accused Zakir Hussain also directed the two accused Bokul Udin and Sabir Ali about modus operandi through mobile phone. On 27/8/2023, both the accused Bokul Udin and Sabir Ali procured the seized heroin. They transported the seized heroin from Nalan village to Karimganj on the same day, but they were intercepted at Seling village. On 28/8/2023, the accused Zakir Hussain left Azol for Karimganj to receive and arrange the disposal of the seized heroin. But he was arrested at Excise and Narcotics Checkgate, Vairengte by SI Larintang in the same night. My investigation therefore proved that the accused Bokul Udin and Sabir Ali consciously possessed and transported the narcotic drug heroin. Accused Zakir Hussain consciously bought and possessed the narcotic drug heroin. The accused Zakir Hussain also hired the seized vehicle for transporting the seized heroin. The accused Zakir Hussain was the real owner of the seized heroin. He also stated to me, "Tuna mimman sak heroin hongzal somni pakohi abain kay matani." Hence, I found a prima facie case under Section 21C against the accused Zakir Hussain, Bokul Udin, and Sabir Ali, and I charged them accordingly for violation of Section 8C of the same Act, and therefore he has submitted complaint sheet. He also confiscated the Bolero pickup. Now, my Lord, in this case, Section 29 is not charged against the accused persons. What is Section 29 of the NDNPS Act is abetment and criminal conspiracy. That was also mentioned in the trial court order. Now, to connect the criminal conspiracy and to come to a conclusion that these persons knowingly possess heroin, the IO or the seizing officer has failed to seize the mobile phone of the three accused persons. Now, in his charge sheet submitted by the IO at page 25, he imputed the allegations against these three persons that they all were consciously possessing the seized heroin. But the question of possession in the bail order in favor of Zakir Hussain was not there. Now, when this trial will continue to its logical conclusion, my Lord, there is no question of acquittal against these three persons. Now, we were hired by Mr. Zakir Hussain to transport Supari. Now, on our initial journey, we do not know there was a secret chamber in the vehicle. Now, even Mr. Zakir Hussain did not tell us that there was a secret chamber in our initial journey from Karimgঞ্জ to Aizol. Now, while traveling to Champhai and on our way back to Nalan, he informed us that there was a secret chamber, and we look at it, but we cannot see what was inside, because when that seized heroin was recovered, it was done at the workshop through a driller, as your lordship will know that while I was reading, my lord. Now, there is no iota of evidence that these two persons, Sabir Ali or the present applicant, knew about that they were transporting heroin at that particular time. My lord, they were arrested on 28/8/2023. Now, it's today is 2022. It's nearly more. It's nearly it's nearly 1 year, and there are 12 witnesses in this case. Only one witness, seizing officer, is examined in this case out of the 12 prosecution witnesses. My lord, if this is the trend, we will be in custody for about 2 or 3 years. So, your lordship has rejected once the bail application due to the reason that at this stage there was no evidence that we were not in conscious possession of the seized article. I'll just take your lordship to here, the order which was passed by your lordship at page 19. No, at page 20, the observation made by your lordship.
Yes.
Page 20, para 7. A perusal of the charge sheet shows that the seized articles were seized from special and hidden compartment made in the vehicle. Thus, prima facie at this stage, it appears that the applicants who are the driver and handyman are aware of the hidden articles kept in the special compartment made inside the vehicle. Your lordship was only making a temporary observation that at this stage means before the examination of the present seizing officer. This bail application was moved before the seizing officer was examined in the court. Now, I don't know whether your lordship will reverse this order or not, but since the seizing officer has clearly mentioned that the accused Bakul Udin did not confess before him that he knew about the secret chamber. And even the seizing officer in his statement before the investigating officer, there is no mention of the word that Bakul Udin knew about the secret chamber. And if I may be allowed to take the advantage of the co-accused Mr. Zakir Hussain being released on bail.
Let's see, look at the grounds.
Yes, the grounds, I understand.
Yes,
It's
the last,
42.
yes.
42 grounds.
No,
was
not 42, the observation of the trial court. Para 4 of the reasoning.
Yes,
It's only because the bank account, there's money in the bank account by GP.
the vehicle was not reported to have been searched, and it's also not been seized.
Para 4, just read para 4.
Para 4. Peruse the application along with its annexes and the cited cases. Also peruse the available materials on the case record and consider the submission by both counsels with regard to the contravention of the provisions of Section 42 of the Act. It is seen that the accused applicant was arrested at Vairante check gate and his alleged vehicle was not reported to have been searched as per the record, and it is also not seized. Hence, the court found no difficulty. And nevertheless, the allegation that the accused applicant paid rupees 10 lakh via GPay for the seized heroin is unsustainable, as there is no evidence in the record to substantiate it and no substance is seized from his possession, and there is no nexus in the record between him and the co-accused or with the seized articles. So the observation of the Lana Special Court is that
No
there is no
nexus.
nexus. Yet even in this case, no mobile phones were seized. We do not know how and when and where they contacted each other. And I am not the owner of the seized vehicle. I was employed by Mr. Zakir Hussain to deliver Supari. The owner of the vehicle is a different person, Mr. Arbes Ahmed. Now here in this case, the IO who has submitted the complaint has made an observation, has submitted a complaint with regard to the fact that they were conscious of this heroin. We, the three persons, were conscious of the seized heroin. Nevertheless, Section 29 has not been added in the charge. Now, if that is the case, Malot, your lordship knows very well about the definition of possession. I may be in another country, I may know what has been possessed inside somebody's house. Now, this person, while he was arrested, he was not in Nalang. He was arrested at Virente check gate. But it appears from the investigation that he knew about what was in the secret chamber. Otherwise,
This
we don't
is
know.
concerning, talk about your case. Okay,
Yes.
this is concerning this person, it is for him to prove later.
Yes.
Okay, now
Now-
your case.
What I would like to submit is that your lordship may permit me that this person has also been released on bail under Section 21C. Now, your lordship has made a temporary observation in the previous bail order that at this stage, prima facie, we cannot show that we were not in conscious possession of the seized article. Now, my lord, the PW number 1, who is the seizing officer, has been examined in the court.
Yes, you've mentioned that.
Yes.
So he
Now
did
that-
not mention her.
That
Yes.
shows that we were not in conscious possession of the seized article, my lord.
Yes.
Now-
Anything else?
With regard to the delay in the conclusion of trial, I would like to point out that your lordship may kindly allow me to go on bail, since this delay in trial is not fettered by Section 37 of the NDNPS Act, which the Honorable Supreme Court has also passed several judgments. And in fact, your lordship has also passed one order, which I may be allowed to place.
Yes.
This is a case of delay in the conclusion of trial. But in this case, the applicant was in custody for 2 years, para 8. And the decision of the Honorable Supreme Court was also highlighted in this order.
How much heroin was seized?
Here, it's a commercial quantity, man.
How much?
Let's see. Alone,
Para 6, 371.
371 grams. But still, it's above 250 grams. It's a commercial quantity.
So he was in jail for 2 years in this case. You have been in jail for 1 year, is it?
Yeah, it's about to become 1 year.
Oh, so you still have time.
Now, here, my lord, in this
More
case,
than 2 years.
at para number 5, Mrs. Linda Larned, additional public prosecutor, on the other hand, strongly objected, submitting that the trial of the case is at its final stage, since only 3 prosecution witnesses are left to be examined. He submits that the next court date for examination of PW number 4 is fixed for 5th June, and the remaining PW are likely to be summoned within a short date. My lord, in my case, there are around prosecution witness. There are 12 prosecution witnesses. Now, if we go by the trend in which that trial has been going on, it is unlikely that I will be released on bail, either on merit after the conclusion of trial. I will be in custody for around 2 or 3 years, looking at that present trend.
Yes. Yes, anything else? Yes, Miss Linda.
Malad, firstly, I'd like to point out that there is no new grounds to reconsider the bail application again, Malad, at this stage. Because perusal of the charge sheet, Malad, it's very clear that the applicant and his friend, the driver and his handleman, they came all the way from Karimganj to Nalan to procure this heroin. And they have been charged under this violation of Section 8C of NDPS Act and have been charged under 21C, which shows that they have not only possession, it's transport of any narcotic or psychotropic substances. It's a produce, manufacture, possess, sale, purchase, transport any narcotic drug or psychotropic substances. And there is a secret chamber, and they have come all the way from Karimganj to Mizoram to procure this heroin. So the submission that they are not aware of this secret chamber is not likely, my lord, because they are the one who procured the seized heroin at this stage. At 24 of the charge sheet, my lord, the investigation revealed that the accused Zakir Hussain hired the said vehicle, Bolero pickup, at the rate of 80,000 to procure and transport the seized heroin. So it was hired from Karimganj all the way to Mizoram.
Hired by?
By Zakir Hussain, that is the co-accused. And the accused Bokul Uddin and Sabir left Karimganj for Aizawl in the afternoon on 25/8/2023. On 26/8/2023, so 25 to 26, one day, the accused Zakir Hussain informed the accused Bokul Uddin and Sabir Ali to procure some quantity of heroin at Nalan village. He informed that there was a secret chamber under the floor of the seized vehicle for concealing heroin. They have come all the way from Karimganj and to procure this heroin. So it was them who had transported this heroin. So the submission that they are not aware of this possession or transportation is not likely, my lord, in this case.
Okay, now the witnesses, let's look at the list of witnesses.
Yes, my lord, there are
Prosecution witnesses.
12 witnesses as pointed out, my lord. And
So only one witness till
one
date?
witness has been examined on June. That was in the month of June. Now we are in the month of August.
So what's happening? You see, they all are from Mizoram itself,
Yes,
Vairengte,
some are
Lumlei,
from Lumlei.
Lumlei.
It may take time, but my lord, we have to see the rigors of this NDPS Act. Because this Section 21C, the imprisonment is for 10 to 20 years. And the trial may go on for another one or 2 years.
Then what about the judgments of the apex court?
My lord, they are likely to be convicted in this case because there is section 35 of the NDPS Act also, culpable mental state of the accused. And the two accused, they are arrested red-handed, and they have to prove their case that they are innocent. And in this case, they are likely to be convicted for a minimum of 10 years. And whether they are guilty or not, my lord, we still have all the witnesses.
We have to have a look.
Now, at this stage, my lord, if I may interrupt, section 29 is absent, which is against the prosecution at first, and they will not establish their case under section 29.
You
And
see, section 29, okay, there are three accused persons.
three accused persons, and the person who owns
My lord,
and who transport the
person
seafood.
may own it, but they are the one, they are.
In
that have
possession
been-
of the
yes,
other two,
They are
so
caught red-handed.
maybe
at this point.
29 will be applicable for the other
Other
accused.
yes,
The one who has been
exactly,
granted
yes.
bail, because the
correct.
seized article was not seized from his possession, but he is still implicated.
Still he's in possession. He may be in a different place, but still,
Because of
Transport
that, it
is
has
also
to
there,
be
my lord. Violation
29.
of transportation of any narcotic drug or psychotropic substance.
now I'm beseeching your lordship with regard to that delay, which the Honorable Supreme Court has time and again passed a judgment, which says that section
You mean,
section
mean the judgment?
737 does not come into play when there is
yes.
at para 4, my lord. Para 4, 1, 2, 3, 4. 4 lines from the bottom. The prolonged incarceration generally militates against the most precious fundamental right guaranteed under Article 21 of the Constitution, and in such a situation, the conditional liberty must override the statutory embargo created under Section 37, subclause 1b, subclause 2 of the NDPS Act. So this is the law as it
And
stands.
so how long have they been in custody, these
Now, in this
people?
case, 3.5 years.
Ah.
Now, the year may be different, my lord. Now, in my case, there are 12 prosecution witnesses, and only one prosecution witness, prosecution number 1, has been examined. And
So I understand your apprehension that now there are 12 of them, so it's going to take almost a couple of years, isn't it?
yes,
So we'll regret the bail application, but we'll pass a direction to the trial court to complete the investigation within a certain period of time.
trial.
The trial with the, and yes, examine the prosecution witnesses expeditiously. Within, we'll make a time frame. If it's not possible, you can come again, isn't it? Within
2 months,
4 months.
4 months.
Within 4 months. Okay. On
My
those
lord, I don't
grounds,
know
we'll
whether it's
reject.
proper to give those kind of time frame to the trial court.
We'll make an attempt. It's not going to
Yes.
be, we'll make an attempt. Okay, not should be. Then let's see what is the condition. If they have examined or almost completed, then we'll see.
My lord.
Yes, I'll pass the order later in those terms. Yes.
For hearing, part 2, item number 2.
Yes, so we have one hearing matter. Who
Lordship,
is the counsel? Yes.
Ms. Dinari,
Oh.
she said she's having some problem in the other court. So the matter may be,
She has another hearing matter in the other.
Item number 2. Now this is a 2014 case,
yes.
so it should be
Can take up
disposed of.
next week.
Yes.
Tuesday.
Mr. Sila Ramzawa, learned senior counsel for the appellant is present. However, it is submitted that Mrs. Dinari T. Azu, learned counsel for respondent number 5 to 11 is on legs in the other court and has sought for adjournment. In view of the above, lists this matter for hearing on, what's Tuesday's
27.
date?
27.
27? Yes. 9/20/23. Yes.